Welcome to Regulatory Ramblings. Our podcast today is brought to you by the University of Hong Kong's RegTech Lab, the HKU Standard Chartered Foundation FinTech Academy, the Asia Global Institute, and the HKU edX Professional Certificate in FinTech, with support from the Faculty of Law. Today's topic is about the consequences of having non-technically trained lawyers advising on matters pertaining to technology. Specifically, lawyers without engineering or hard science backgrounds, most typically those without STEM degrees. In the US, for example, one has to have a STEM background to sit for the patent bar and appear in matters before the US Patent and Trademark Office. Yet, oftentimes in Asia, particularly in the hubs of Hong Kong and Singapore, one encounters dispute resolution practitioners who present themselves quite freely as technology or fintech or Web3 lawyers. Question is, are clients being shortchanged by having lawyers who aren't techies and may not fully understand the underlying matters that they're advising on? To put it another way, is it permissible to only know the black letter rules of law and the formalities of filing procedures when advising on technical matters? That is the question. And our guests today will hopefully shed some light on the matter. They're both returning Regulatory Ramblings guests. Ronald Yu is the director and co-founder of MakeBell Limited. He's also a visiting fellow at City University of Hong Kong and a part-time lecturer at the Chinese University of Hong Kong. As a scholar, his areas of interest are the nexus of law and technology, specifically intellectual property and NFTs, artificial intelligence in the law, cross-border data flows, and computer forensics. He also teaches a course on fintech at Chinese U with our next guest, Don Day, and he's also taught patent law and intellectual property law in information technology at HKU. Donald Day is the Chief Operating Officer of VDX and the co-founder of CFAR, an organization we mentioned before. Don Group VDX builds digital asset ecosystems for institutional investors, and most notably, he's the former in-house cryptocurrency and digital asset expert at the local capital markets regulator here in Hong Kong, the Securities and Futures Commission. There, he helped shape the licensing regime for virtual asset trading platforms and designed and led the supervision of the virtual asset fund manager trading platforms. And it is with a very heavy thank you that I extend our greetings and salutations. Gentlemen, thank you for joining us.
Thank you. Thank you for having us, AJ.
What are the consequences of non-technically trained lawyers, specifically those without degrees in engineering or the hard sciences, basically STEM degrees, offering advice in situations where technology is either implicated or at the core of the matter? I know you're chomping at the bit, Don, so I'll let you have the first word.
Of course, when legal advice is required, often, not always, but one often is facing a challenging situation. Sometimes not so challenging. It might be a contract, it might be a non-disclosure agreement, it might be a deal. Other times it could be a compliance or regulatory or even legal challenge, and it might even go to court. So for all of these matters that are deeply technical, and that goes for engineering, it goes certainly to computer science, and in our case, maybe a fintech area, lawyers will often need help from technical experts. You mentioned the STEM degrees in the US, and that is great, but more often than not, a lawyer would not have had the opportunity to study for an engineering degree or similar while studying for law. I myself, I've been a technical expert at Corsia in Hong Kong, and I've frequently done training courses for lawyers and for regulators about technical matters and also trading matters. Now, lawyers usually are very smart, right? That's why they're there, and that's why they practice as lawyers. So they're able to pick it up quickly. And I think those lawyers, the smartest lawyers, quickly realize up to what point they can give advice and to what point they would need to bring in a technical expert to facilitate their legal advice. So therefore, I think expert witnesses would be a really important part of the process. I'm sure Ron will be able to add something as well.
I personally do not think that a STEM degree is an absolute prerequisite for two reasons. One, because a STEM degree in one area does not necessarily mean that the expertise transfers to another area. And the other thing is you do have examples of lawyers or judges who are not technically trained in the formal sense, but have been very successful in their very technical practice areas. For example, you have Judge Randall Rader, the former head of the Court of Appeals Federal Circuit in the U.S., or i.e. the U.S. Patent Court, and his background is English. He was an English major, in fact. Now, what I think is actually also important, if I also may add to what Don said, is the ability of the practitioner to constantly learn and update their skill levels, whether or not they have a technical degree or not. For example, in the case of AI, they should be willing to learn about AI, its advantages and its disadvantages. You've heard, no doubt, about the case in America, Mata versus Avianca, where you had two lawyers who were sanctioned $5,000 each for using cases that were fabricated by ChatGPT. What was actually more incredible was that since then you had a case in the UK, Haber versus Commissioners of His Majesty's Revenue and Customs, as well as a case in Canada where a family lawyer in this instance had cited non-existent cases that were fabricated by generative AI. So I think it's not just a question of background, but also the willingness to update oneself.
I'm glad you brought up AI, and the Canadian case was widely reported on. It was by CBC. The videos are up on YouTube, and they apparently took pains to point out that it wasn't a matter of the lawyer using the AI to fabricate the cases that they would later cite, but it was them using carelessly, lazily using AI, which itself fabricated the cases. And I don't know if it's a distinction without merit, but the court seemed to understand that there was it wasn't outright maliciousness. It was more laziness on the part of the lawyer using generative AI in that instance. But okay, right. We're entering an age where things are getting more complicated. Things are getting more specialized. On some level, yeah, all this technological stuff, if one understands the bigger picture, they see it's all connected. But to the person on the street, a lot of this is compartmentalized and specialized. In an age of AI, machine learning, large language models, and people are talking about, the tech of law, the law of tech. I mean, we're beyond the law of tech now. The focus is more on the tech of law. To what extent do lawyers need to code? Ron, you told me once that you don't think they need to code, but increasingly it seems like code is becoming more part of the discussion. Not least of which in the context of smart contracts.
Given all the tools now available to help you create code, for example, Copilot, learning to code is not an absolute prerequisite. That being said, I don't think it's a bad idea to learn to actually code an application, simply because it gives you some appreciation of what goes into the process of making an app, and also it gives you some technical background and vocabulary so that you can deal better with technical people that are involved with, for example, creating applications. But that comes with the caveat. that knowing how to code does not automatically enable one to understand some of the background technologies that may also be involved with the coding or the software, or that you are using the software to enable. For example, learning to code does not mean that you have expertise in AI. It just means you know how to code. It's a bit like learning how to use a frying pan. Just because you learned how to use a frying pan today doesn't mean you're going to go out and make award-winning Venus schnitzel the next day. I think what you have to do, you have to note with coding is not the process of coding, but you also have to be aware of what you are using the software for, and to also understand some of the advantages and limitations of the other technologies you're calling into question. Again, going back to AI, you have to be aware of what you're doing with the code to call up an AI program, or use an API or whatever.
To add on to that, so on a very high level, to become an expert, there's this line that you need to spend 10,000 hours in the field. To become a good lawyer in any country in the world, you need to study quite a long time. And then you need to practice, and you need to gain practical experience before you'll be allowed to practice law. And then again, there's no lawyer who covers the whole field of the whole legal field, right? Lawyers specialize in certain areas. Some are solicitors, some are barristers, some are litigators. They focus on specific areas of the law, and so on and so forth. I found it quite amusing when someone like Kim Kardashian thinks that she can take what is basically an evening class and then thinks she's a lawyer. Likewise, I've worked with people who took a similar class in programming and thought they can code. So being a good programmer takes years. You study something like computer science or engineering, and then you need to gain experience in real life, and that again takes years. So having said that, and I do agree with Ron on that of course it helps to get a better understanding of the frameworks, the mindset, and the approach of programmers. If, let's say, a legal practitioner enrolls in a online course to learn how to code Python or C# or something like that. But I think Ron pointed out the danger of becoming overly confident. It's always important how much you know and how much you don't know, and especially how much you don't know. While it's important to seeing how computer code works, what kind of errors can happen, that can help lawyers better understand the technical challenges. But again, you're scratching at the very surface of a very, very deep barrel, right? And then, as Ron correctly pointed out, we're only talking about programming. Specifically for AI, it's important to know how to talk to it. We've talked about the famous cases of the US lawyers quoting cases that didn't exist. So we're not even talking about programming AI. I think that would be beyond. I mean, I know people who do that. I certainly did it when I studied computer science at the end of the last century, and that's a whole different area by itself. But just knowing how to, in a way, talk to AI to get the results you want, that's in itself a science, and that probably is something that lawyers would need to be aware of and would need to be quite experienced in, because AI is incredibly complex. And the usual AI we talk about, right, that works on an unclean data set, which is fraught with errors. That's fraught with dangers because it contains a lot of errors. When you look at market data companies, for example, they increasingly use AI because it helps their users get to where they need to get quicker. But they employ hundreds of people to make sure that the data set on which the language models work is clean and correct. And they employ, again, hundreds of people who filter the results that come out to make sure those are correct as well, right? So this is highly complex. It's not just I switch on my computer and type a few questions to ChatGPT and I'm done. So that approach would be very, very dangerous.
No, I appreciate you saying that, because I was talking to someone at one of these big consultancies who's in the AML forensics field, and his point was he's not a techie, but he became familiar with the technology by virtue of the job he was doing, by prescription, by necessity. And what he said was, the thing about generative AI was, it comes down, you don't necessarily need to be a techie, but he said you need to know the subject matter well enough to write good prompts. And that's something Ron and I have discussed in the past as well, that you need to know the subject well enough that you can ask specific pointed questions. If that's the case, then you're less likely to get it wrong. But I mean, I was amused, Don, by what you said about Kim Kardashian. Yeah, that's the U.S. legal system. You get your your JD in 2 to 3 years, depending on how many. If you want to do summers as well, you get your 84, 90, 99, 120 credits, whatever it is at your particular school, and then you take the bar exam. The view is you can hang up a shingle. Anywhere else certainly not the civil law world, but even in the common law world, there is an expectation that if you're going to go down the barrister's path, you do a 2-year pupillage, and if you, or is it 1 year? I forget in Hong Kong, but and I think it's a 3-year trainee solicitorship if you go down that path, and yeah, I mean that's. It's also been said that technology kind of time change the rules of the game, and sometimes lawyers suggest contractual terms, and I want to put this to you, Ron, that once upon a time it was said that if you wanted to be a good lawyer in the field of, if you wanted to serve investment bankers and private equity types well, you needed to not only know the law of contracts well, and the law of securities regulation and business association, but you also had to understand the fundamental business of what these private equity and hedge fund and investment bankers were doing, so as to draft the best contracts. So if we were to apply that analogy to our time, the 21st century, how tech savvy does a lawyer need to be? Does a lawyer need to have some rudimentary coding ability to be the architect of a good smart contract?
Okay. First off, in terms of smart contracts, I think what the lawyer first has to recognize, and I hope he or she does, that a smart contract is not the same thing as a traditional legal contract. Consequently, you have to treat it differently. For example, if you want to code in a force majeure clause into a smart contract, you don't do it the same way you would write in a force majeure clause in a paper contract.
Just to stop you there, we should let our listeners know, force majeure is often likened to an act of God.
Yes.
Clause, and something that no one could have anticipated. Sorry, please continue.
Yes. And so what's involved in coding a force majeure clause? You'd have to define what is a force majeure act. What is an act of God? Second, you'd have to define the threshold in which to trigger a force majeure clause. So, what is the threshold? And then if you wanted to have the system automatically trigger the force majeure clause, you would need some mechanism to inform the contract that something has happened that requires the triggering of this clause. But then if you take for example, a news feed to provide the smart contract with the requisite data so it knows when a force majeure event has occurred, you now have the problem of a potential cybersecurity risk, because you've now made this smart contract open to to external data. So you got all those considerations to take into account just for one force majeure clause. And so whether a lawyer can code or not doesn't mean that a lawyer would also be able to think through the process, not just of coding in the definition of act of God, the threshold for triggering the contract, as well as the cybersecurity issues. Just learning how to code does not give you those skills automatically. And as Don correctly pointed out, there are quite a few things to learn when you're doing software programming that come only with some experience and over time.
Yeah, to maybe add on to that, because there's an important point that Ron pointed out that is a bit subtle. The word smart contract is actually not a great description for what it is, because it is not a contract. It is a computer program that is somewhat encoded in a blockchain that gets executed by the virtual machine. The past 24 to 36 months have shown how complex that is. And I'm not even talking about hacks, and I'm not talking about malicious actors on purpose putting trapdoors into these programs, which certainly has happened. But I'm talking about bugs that weren't found and slipped by and then caused assets to be frozen or assets to be lost or assets to be absconded with. So I think there's a better name would be good. There's also, as of yet, no legal enforceability on any smart contracts that I know of. But what is going to happen, that's probably a very interesting field, is that there is a lot of opportunity in the area. And there's certainly a lot of future growth in this field. So what will, of course, be required will be people and entities, firms that can do an audit on these smart contracts. The first ones are available, but there will be a need to much more. And hopefully also legal experts who can make an assessment on whether this program would really resemble contract and can be seen, and how it can be seen in a legal field. And that goes to your point, AJ, at this interface between technology and legal parts or legal areas. How can you assess a computer program and then make a judgment on whether that could be seen on a similar level as a contract that is written down on site? So I think that's going to be a huge growth area, and there's going to be huge potential for any legal practitioners who have the required technical background, or of course any engineers who then get a second degree in law as well.
When one thinks about the common law world, I mean, most of us that got our degrees in law in the common law world, I think this is uniformly the case that when you start off your study of contract law, you're taught the definition of a contract is a legally binding agreement. So there's this other category of things called quasi contracts, which are bound by maxims of equity. If a smart contract is not the same as a contract, then do we equate it with a quasi? Is it a quasi contract? I mean, I guess where does it fit in the common law nomenclature?
I think a smart contract would probably be governed by an actual contract, so it's part of the terms and conditions.
So it's an appendage to the actual contract?
Yeah, more or less. It's like if you use Facebook, you automatically you sign the agreement or agreed with the agreement, and then you have the its AI and data collection all come as part of this agreement. So I would think that was the better way to go about it, because and then you have certain jurisdictions that may recognize a smart contract as something equivalent to a actual contract, depending on what it does and how it operates. But I think it's probably safer to assume that it would be part of a subordinate to another user agreement.
Okay.
this is where it becomes really interesting, because quite often, more often than not, smart contracts are used in the decentralized finance world. And there, of course, people don't formally sit down and sign a contract before they engage with each other. And there might be countries, continents apart. So I think there's going to be a lot of questions that need to be answered. I don't disagree with what Ron said and the definition, but I think that there's going to be a lot of miles that need to be covered before we get there.
So, in a world where technology can change fundamentally the rules of the game, sometimes lawyers suggest that contractual terms are legally feasible based on the current state of technology, but they're not practical, such as the Bitcoin 10-second consensus period, a performance requirement that's not possible to do. I mean, if there are terms in the contract that are unworkable, could that lead to a lawyer killing a deal out of ignorance of the underlying technology or lack of commercial savvy?
Well, AJ, if I may, lawyers have been killing deals without having to be technically competent. Or I can give you an example in my case where I had a lawyer who almost killed a deal because he did not understand the apostille process, and that is a legal process. I think a lawyer who is not technologically competent can potentially kill a deal, but there are other dangers that one has to be aware of. For one thing, a lawyer who's technologically incompetent may cause his client to spend more in terms of legal fees than is necessary. You have cases in America, for example, DR Distributor and 21st Century Smoking, where you had judges sanctioning lawyers for essentially incompetence in e-discovery. Okay, so these lawyers not only wasted a lot of court time and caused customers to be billed excessively, but also lost a lot of data because of their incompetence. The other things that they have to be aware of is that there is a potential loss of confidence. You mentioned prompts in AI before. You can actually potentially lose confidence in prompting. My business partner, for example, was so concerned about this, he actually wrote himself a app to redact data so that he didn't accidentally disclose confidential information to ChatGPT, for example.
Yeah, I think it's a very important part. Of course, you need to be able to do business, right? And when I think back to my days on the trading floor at a global investment bank, there was always not always, but certainly very often the debate between compliance and trading. And of course, traders need to be sometimes reminded of how far they can go and what the legal boundaries are. But at the same time, if compliance, by extension legal, is overly cautious, you wouldn't be doing very many deals and you wouldn't be doing a lot of business. Because if you take an ultra-conservative approach in everything you do, it very quickly becomes very, very difficult. The same obviously also goes for regulators. Now, I'm a big fan of regulators, having worked at one. I think they do a lot more and better work than they're given credit for. At the same time, it is important to see the business and commercial realities of the world we live in. And enforcing a rule where only one jurisdiction enforces the rule and nobody else makes it incredibly difficult for people in that jurisdiction to operate in a global asset class. Putting it up there.
Now, the thing that leaps out at me is that, look, clearly the more technical subject, the less likely your average dispute resolution lawyer at a typical multinational Anglo-American law firm is going to be able to be up to the task. So then as a practical matter, that means you have a very narrow field of specialists who understand both the law and the underlying tech to choose from. I mean, how do clients then pick the right lawyer? Because the view is that amidst all the hype and the marketing it's hard to know who genuinely has the knowledge. If you're a layperson, the market is opaque in that sense, and whereas, okay, the model rules of professional conduct, or we're talking about legal ethics now, in the U.S. states, you're not allowed to say you're an expert, but you can say my practice is centered on this particular area. But I don't know. I mean, at least in Hong Kong, the superlatives and then the over-the-top hyperbolic language sometimes that I see used by the legal profession to promote itself, it gives me pause. So again, where do you go? To whom how do you pick the right lawyer if you're a client?
For me, it's all about the personal connection, the trust. I think both are key. You're absolutely right when it comes to the hype, especially here in Hong Kong and Asia. So for us, I think it's that we look at maybe previous cases the legal profession might have been involved in, to a degree that they're public, maybe publications or conferences where the lawyer has contributed to or spoken at. We talked a lot in the beginning about additional certifications that might be useful. And again, yet one has to be careful that they often only cover very limited knowledge base. I do think professionals in any field deserve credit when they openly admit to not knowing something, and offer to bring in experts. So if a lawyer said, I'm not an expert in HSM management, so I'll bring in an expert if we need to talk about that, then I think that's fine. I would be remiss not to mention involvement in groups like CIFAR that you mentioned earlier on. That's a non-for-profit dealing with crypto fraud and asset recovery. And certainly if a lawyer is involved in an organization like that, they will pick up additional knowledge, right? As you said, and I'm fully aligned with you there, AJ, I would really counsel against the most aggressive, the loudest, and those that pertain to be experts. Usually, almost 100% the cases is exactly the opposite. And one has to be careful about the type of organization. Some quite loud fintech associations, especially here in Hong Kong, aren't really particularly staffed by experts. So, but the whole market knows that. So I think overall, it is the personal relationship one builds with a lawyer. It is the trust one builds with a lawyer. It is the service one gets from a lawyer. And this often is a relationship that is built over time, right? I have a good set of lawyers I would trust, and I know exactly who to go for, depending on what kind of problem I have. But that hasn't come overnight, right? That's a process over months and years. So I don't think there's a quick win. I don't think there's a shortcut. I think it is, as with everything, you build these relationships with time. Also maybe going through a difficult period and who was there gave you really good advice, and maybe it was at 10 p.m. where they gave you that advice.
I completely concur with Don when he talks about not trusting the loudest voices. And also I would completely concur with him that the best judge is time and experience with the particular person. That being said, one also must do some due diligence. Just for your information, what we were doing in my startup was we actually built a smart FAQ, essentially an AI-powered chatbot to answer questions about virtual assets in Hong Kong and the licensing. And you could conceivably use tools like that to double check some of the people that you might be looking at to see whether or not they actually know what they're talking about.
That's a valid point. I mean, and I like what you said earlier, Ron, though, about how lawyers have been killing deals for a long time, and sometimes it isn't even technical knowledge or the lack thereof that causes it. But I mean, I remember my investment banking prof, and his experiences mirrored mine. But There was a situation once where I was doing research for a law firm in Chicago, and I was invited to sit in on one of the deals. And then what struck me was, there were certain lawyers that were more business savvy. There were certain lawyers that were more about getting the deal done. And then you had your pencil pusher types who wanted to scrutinize the minutia. And they were constantly busy telling you what you couldn't do, and the investment bankers didn't like that. And so, not infrequently, it would reach a point where they would send most of the lawyers out of the room until they were ready to draft the contract. Some were allowed to remain because they were seen as adding value to the deal, and they were business savvy. When they spoke in the same language, they had that rapport with the investment bankers. And then they hammered it out, and then the rest of the legal team was allowed back in when they were ready to draft the contract. And again, it shows sometimes that there's a rigidness to the legal profession that's anti-commercial. It's anti-business. It gets in the way of things, even though they're trying to protect you from that 1% scenario where everything goes wrong. That's why where a comma in a sentence matters, for example, is an extreme case.
Exactly. I mean, there's a difference between protecting the business people from, I don't know, violating regulatory requirements, violating the law, basically keeping them out of prison, and obstructing business, right? And on one side, you enable business as much as possible and tell people, okay, you can't do that, but you can do all the 85 other things, versus being overly conservative to the point of preventing commercial success.
But I'd also point out you can also have lawyers who are overly conservative, who don't understand that the implications in other areas, and so that sometimes the advice that they're giving for example, to overprotect their clients may in fact be not just counterproductive, but possibly illegal without them actually recognizing this. I also like the point you brought up, AJ, with regards to the United States. I think you were referring to ABA Model Rule 1.1 of the practitioners' guidelines, if I may. I think it's actually very good that they included technical competence as part of a lawyer's overall legal obligations because of the very tight integration of technology with everything we do nowadays.
On a related note, this is an article I saw in the ABA magazine. This is about 20 years ago. It was in 2000. There were two cases that went up, I think, before the Supreme Court, Daubert, Frye, and they created a standard of, what expert witness testimony. And the crux of it was that a lot of judges weren't abiding by the Daubert-Frye standard. To put it simply, the view was expert testimony is so overrated. It's so oversold. It's so overhyped. The judges were starting to become more scrutinized, even if they themselves didn't have direct expertise in that subject matter, that they were starting to say, no, based on common sense, I'm sorry, what you say. They were outright telling the experts, based on common sense, what you're saying doesn't resonate with me. And that's interesting. People holding themselves out as experts. Sometimes you get people to defer to you. In certain markets, it's not worth all that much currency. But to play devil's advocate, it's been argued that even a non-techie, as you point out, Ron, can bring themselves up to speed by educating themselves, as we've seen in fintech and crypto. A lot of people who generally know about the subject aren't techies. But then we can agree there are times where there's no substitute for the right kind of technical background. Patent lawyers not infrequently have to deal with solicitors who don't understand the tech, and those solicitors become a hindrance. That's why some claim it's not ideal to engage in IP-related litigation in Hong Kong because of the lack of talent. and that even if you get a specialist who carefully explains the subject matter to the solicitor, invariably they'll get it wrong or they won't understand the subject matter. I mean, am I giving the local profession a hard time, or is there truth to these stories, these tales of woe?
Well, I have heard more than one overseas patent and IP practitioner make that complaint. That being said, I think there are now quite a few solicitors who are very competent technologically, and I think, in the case of my complaining friends, they simply got the wrong solicitor. Because again, had they found the right solicitor, I think they would have found that these solicitors, for example, would have been giving counsel proper instructions. That being said, since you mentioned IP, I think going back to an earlier point about commercial competence, IP now is not just dealing with things like, technology. You're also dealing with some complicated financial considerations, particularly in licensing, and I'm talking about patent licensing here. My class last week had a guest lecturer who was talking about the Oppo and Nokia case that was held in the Chongqing No. 1 Intermediate People's Court. And this involved 5G licensing and the royalty rate that would be fair and reasonable to all parties concerned. And this guest lecturer himself was telling us how difficult the financial calculations were and why they were hard to understand. So in a case like this, you not only had to have some degree of technical knowledge, you also had to have some appreciation of the industry, some knowledge of the royalty rates around the world. You had to have some knowledge of finance, and because of the mathematics involved, you had to at least have some minimal competency in mathematics. So here you actually had a case. While it's a patent case, it was actually dealing with patent licensing. And again, the expertise in this area was well beyond technological.
Yeah, that's a good point. I mean, in the broader area of specialized knowledge, let's say it's a complex derivatives transaction that needs to be litigated, or it's some technology field, it's probably not feasible to expect any lawyer to have deep expertise for something. You might need to be a practitioner for 20 years. There's certainly a reason why it takes time to become a good FX derivative structure, for example. I do have quite a bit of trust in our Hong Kong legal field. I've come across some exceptionally smart individuals and professionals there. When I worked at the regulator, there were certain areas where I did explain fairly complex matters to our legal department to prepare the relevant court documents. And I was impressed how quickly they got it. And it's quite funny, when they summarized what I had given them the input, it was like me reading something that for the first time. It was exceptionally well structured, but I had to remind myself that the content actually came from me. So again, it goes back to what you said earlier on, AJ, right? You need to find the right person. You need to find the right legal partner to engage with that.
Is there a case to be made for what was once upon a time described as blue ribbon juries of the educated, juries of specialists, juries from people made up by members of particular profession, specialist experts? And I'm using that term not as a term of art, but in a more generic sense. That would aid in the deliberation of such matters when judges, maybe they've gained the expertise, but by hearing enough cases in that area, or maybe they lack the expertise. But is there something to be said then that a blue ribbon jury could help in such determinations?
Well, you made earlier point about common sense, and I think there's a lot to be said for common sense. Oftentimes, especially in the nascent fintech areas, find experts who go into insane detail. And from the outside, I always have two observations. One, is there an actual problem that you're solving? Two, will you ever be able to commercialize this? Will you ever be able to make money? And if you can't, then you don't have a business. So I think common sense is actually an incredibly useful tool. Now, is a jury always the right instrument to assess a deeply complex technical financial problem or case? That's quite a difficult question, but I think it's then up to the expert to explain it in terms that is readily understandable by a layperson.
I think if I might add to that, I would agree that a lot of experts cannot talk to a normal person, and it is underappreciated. The skill of explaining technical detail to a layperson is an underappreciated art. With regards to blue ribbon juries, I think one has to be a bit careful. One, because some of these experts may have very, very strong opinions that may prejudice a case. For example, I think when you will recall a few years ago that smart contracts were all the rage, and you had all these quote-unquote experts talking about how smart contracts would replace paper contracts and would ultimately replace lawyers. I mean, if you have a jury full of people like that, in a dispute, could one party get a fair hearing or a fair outcome? That's a good question. The other part that you mentioned with regards to expertise and common sense also is very much, I completely agree with Don. You have to have a degree of common sense to, adjudicate cases. Now, what you could do is do, for example, like what the Americans do with patent cases, where you have what they're called Barkman hearings, and these hearings would be pretrial hearings where people could discuss technologies and vocabulary, so everybody is at least on the same page. Otherwise, you have people with, coming in, let's say, for example, talking about AI with wildly differing definitions of what AI actually is. So that, I think, could be something that could happen in the future.
Don, I'd like to put my next question to you, which is that I'd be keen to hear what you have to say. That, I mean, it's often the case that lawyers view technology through the lens of legal and regulatory compliance requirements, with less focus perhaps on the implementation of said technology and how it'll work and how and where best to use it. Where's the best? How do you deploy it? And if there are any cybersecurity issues, well, that's IT matter. That's their lookout. That's their remit. So that critique of lawyers, they tend to be very insular. They tend to be compartmentalized in their outlook. It strikes me as when you're dealing with technology and all the spillover effects that it can have, it strikes me as pretty myopic and concerning. But then how do you get people to after all the training they've got, which has taught them to emphasize, zero in on the issues? What is justiciable, what is legal, what is actionable? When you come from that kind of training, just really bear down on what the essential issues are, and that's what you argue over. How do you get them to have a more holistic view of things? What do you think?
I think you point out a very important part there. It's about how lawyers are trained, how they're educated throughout their studies and their training. So I've certainly come across lawyers who are exactly like you said, they're maybe not myopic, but fairly narrow-minded. They're very focused on doing things their way, and then it becomes quite difficult.
Once they've got the blinders on to variables that are, okay, then maybe they're external, but they're definitely relevant to the matter at hand.
Exactly. And there are a lot of areas, especially in the world we live in today, that is very interconnected, that it would be not prudent, for example, to say cybersecurity is a purely IT or technical topic. And likewise, when, let's say, you file an application to a regulator and you contract a legal firm, a law firm to review and help you word it, they can, of course, word it very well. That's what lawyers are trained to do. But I wouldn't necessarily expect a deep technical review. I wouldn't expect a lawyer to give me a lot of advice on whether a certain approach that is being suggested is sound from a technical perspective. And that's something anybody who engages with, let's say, a regulator and gets advice for an application needs to deal with. He needs to be aware of that. And having said that, there are a lot of very good lawyers, including in Hong Kong, who take that more holistic view, who want to enable business, are very commercially savvy, and take the approach of, okay, let's make this happen. I'll protect you from a legal perspective. I'll help you with the areas you need to cover. I'll help you with how you comply and state that you comply with legal and regulatory requirements, but at the same time, do it in a way that is technically feasible. So they exist, but you need to pick and choose and be quite careful about that. And I've certainly seen both sides.
Ron, you're an academic lawyer. You're also an entrepreneur. And I was struck when you recently mentioned to me that that you knew a firm that applied to the SFC for a VASP, virtual asset license, and they got bad advice. And I believe the SFC denied their application. And when I heard that story, to me it underscored the point that when there are consequences, it can be more than just a slap on the wrist, especially with something like this, a new field that Hong Kong is keen to grow. They want to maintain their standards. They want the rest of the world to know that, we run a tight ship, that, our standards are not sloppy, they're not slovenly, they're not slipshod. And, Hong Kong is a place to do business because of a sound regulatory regime. That in a market like this, in an environment like this, it's a mark against you, and you're in the regulator's bad books, and they'll be paying even more attention to you moving forwards. So even if you're well advised on the obvious legal and technical aspects at stake, through no fault of your own, if a lawyer overlooks the performance and cybersecurity issues, they're glossing over important technical details which can harm your interests. So what's the solution, or do you just have to live with such risks that, former U.S. Secretary of Defense Rumsfeld said in the aftermath of the Iraq War of there being unknown unknowns? Things we don't know.
Well, first, the story was told to me by somebody else, so I heard about it anecdotally, so I don't know the full details. Secondly, in terms of the virtual asset space, I think a lawyer cannot segregate the technical details with the legal details. A lawyer certainly should not be outsourcing all the legal, the IT stuff to the IT people, because for no other reason, the terms and conditions of the VASP license talk about, devote quite a few pages to cybersecurity, IT infrastructure and operations, and to things such as safeguards, for example, against bad data entry errors. So I think when you have something like this that is so integral to the licensing conditions, any lawyer who does not also adequately address the issues of technology, the issues of cybersecurity, is doing a disservice to his clients. That also being said, I might also point out that in this area, if you did have a dispute with involving a virtual asset provider, you would a lot of the data would be digital. So competency in digital evidence would also be required. And again, the process of e-discovery is such that a lawyer cannot outsource certain obligations to IT people. And finally, I also point out that if a lawyer is not competent in these areas, either he or she should find the right experts to call upon, or just simply be honest and tell the client, I'm not an expert in, area X.
Yeah, let me add on to that. Having been at the regulator when the initial VATP regime came out, I helped shape it. And then now being at a firm where we're actually applying for VATP, VASP license ourselves, experience shows that I think it is up to the applicant, and it's the applicant's responsibility to make sure that the advice they get is sound, is accurate. They can't just take the advice from an outside consultant law firm and just forward it, basically. Of course, lawyers are able to add different value than, let's say, a technical expert. So quite often lawyers would refrain. I've seen lawyers refrain from certain areas, saying, I'm not an expert. I wouldn't be able to assess what you've done in that area. I wouldn't be able to give you advice. We need an expert, a technical expert, or a compliance expert, an AML expert, whatever the case may be, as the case may be. And then you need to be quite careful, exactly as said before, what the advice is given to you. Because at the end of the day, it's not the lawyer applying for a license, it's the applicant. And it's up to the applicant to ensure that their representation in their submission to the regulator is accurate.
For practical purposes, they need to check. They almost need to double check the lawyer's work. They need to double check the lawyer's advice to get a second opinion. It almost seems to make sure they're in the clear.
I would say triple check even. I mean, we talked about common sense, right? Before. And of course, if you get advice from a lawyer, if you get certain review from a lawyer, it's not that difficult to check that against the regulatory requirements, check it against operational realities or technical realities or financial realities. I don't necessarily want to go as far as to say you need another law firm to engage another law firm to check that the first law firm's work. That would be not commercially not very viable. And if you engage with a good law firm, you should be able to trust the legal part of the advice. But you certainly need to confirm, critically review any input you're given from whoever you're given that input. That's for sure.
It's interesting because, I mean, there was a situation where a big four firm was involved, another consultancy type investigative firm was involved, a major law firm was involved. All three apparently screwed things up to the point where a real specialist, a friend of ours, Julian Russell, corporate investigator, had to be brought in to undo the poor shoddy workmanship of these large high billing firms. So I guess gone are the days where you could say, well, I consulted with a Magic Circle firm, I consulted with in the US, a white shoe blue blood law firm. That's what they told me. I mean, and I think that, different scenario, but same underlying dynamic. Haim Saban, back in 2006, a Jewish American billionaire who got caught in the KPMG tax shelter case. And his advice, well, we went to KPMG, a Big Four firm. That's what they told us. I thought it was legal. I thought it was kosher. I thought all was good. But, didn't work out that way. So even though people will deliberately go to these big name firms because they want their imprimatur, they want that, they want that shield in case a regulator asks them, well, we got advice from the top firms in the field.
As you know, AJ, this is one of my key complaints about this asset class specifically. There's certainly in the past have been people, and usually those people who spoke the loudest, and were surprisingly, given the biggest platforms, had very little to no knowledge if you went a millimeter below the surface. You could argue that those who really have and had and have the knowledge are too busy building things and making money. But I also believe that this is changing. Especially here in Hong Kong, I'm incredibly proud of the hard work that has been done at the Hong Kong regulators, both the SSC and HKMA, and a lot of other people coming together. And what you can see is that one of the positive effects of the regulatory regime is that real professionals are coming to the virtual or digital asset markets in Hong Kong. By broader extension, fintech markets. And you see a lot of people leaving their fields in their jobs in traditional fields like traditional finance, legal profession, compliance, market data, and enter the fintech area in Hong Kong specifically because there is a trustworthy regulatory framework. And the more real professionals we get, the more the charlatans and snake oil salesmen will be driven out. But one has to be very careful. It doesn't take very long. It takes maybe a week or two with Google to have enough buzzwords in one's arsenal to come across as an expert. And it takes a little bit of work to sort of like start peeling apart the onion and see how much value there is in there.
Also, AJ, to your point earlier about the people using the big names, I think that speaks also to human behavior. I mean, this is just not limited to law firms. You had people, for example, who would spend more money to buy inferior solution from, say, a big name computer maker rather than a superior, cheaper solution, simply because of the name, and they wanted the political cover, in case something went wrong.
If you're looking at this as a student, any fields, particularly in the subjects of law and business, and you're looking at this as a student, and you're like, okay, so do I take this course on AI and machine learning that doesn't have coding and that'll get me ready for the field? Do I take the certificate in FinTech and then I'll be off to the races? Or grown, now I have to learn all this stuff about tech in addition to law, the legal side and the financial side of it. I mean, what advice would you give young graduates seeking to make a living for themselves, but to chart a career path for themselves in these new emergent fields of technology? Because if there's something a message that's come through for me with all the people I've interviewed over the course of close to 2 years on this program, that you don't necessarily have to be a techie to have a place in the world of fintech, crypto, Web3. But you have to have a curious mind. You have to be able and willing to learn on the fly, and you have to be adaptable. Skills that sadly many Hong Kong graduates are not known for. Or maybe I'm being too harsh. I'd like to hear from both of you.
Well, I teach a IP commercialization class right now, And one of the things that I teach the students is that the intellectual property is business related. And really, you cannot separate the two. If for no other reason, because the value of your intellectual property is very much dependent on what you do from a business standpoint, but also what you do or fail to do from a legal standpoint. So what I advise is that they get more broader perspectives on things and to be a little bit more open-minded and not go down a narrow path with, as you said before, with blinders fully activated. That being said, if you go into the technology field, you have to be aware of the nature of the technical space. It changes fast. New things come on board. There are limitations to the technology, no matter how sexy or attractive it is. I mean, for example, let's talk about generative AI. Okay, everyone looks at it and they think, wow, this thing can think like a person. However, if you look deeper into it, you realize it has certain limitations, for example, with planning or with reasoning, okay? So it doesn't think like a human being, no matter what the output of ChatGPT or Claude looks like. And so you have to be not just aware of the technology, not just have the ability to keep up with the technology, but also understand how the technology works and why it does what it does, good for good or bad. This, however, also means that they're going to have to be prepared for a lot of fast changes, and they have to be prepared for burnout, because one of the problems when you deal in technology is that things burn out, that you be burnout because you learn, for example, about a new tech, you become expert in the tech, and then what happens? 2 years later, it's obsolete. That's just part of the technological environment. And you have to be aware that this happens, and you have to constantly keep yourself updated. For the students going into law, their professors may have learned law in an age where things don't change very quickly, or certain areas don't change very quickly, for example, in constitutional law. But if you're getting into areas like IP or nowadays FinTech, things change very fast. You have to be aware of it, and you have to stay abreast of all that goes on.
I think it would be helpful if, as a student, one knows what niche one wants to carve out for themselves, because that will inform quite a few career choices. So my first degree was computer science, but I knew I wanted to be in financial markets. So it was a technologist with a strong financial markets interest and background. And then later I switched that slightly and became financial markets professional with a strong technology background. And like you mentioned in the beginning, AJ, I taught a regulatory technology course together with Ron last year. We brought in a lot of guest speakers, and you could clearly see those students who really appreciated this outside knowledge and who were starting to think, okay, so this is an area that I might be interested in. How do I get into that area? So as with anything, there are no quick wins. One can go the quick route, like you said. You don't need to be an expert, and you can still make a name for yourself. You can go the maybe a bit longer route, but probably more solid route, and maybe do get a second degree, a more engineering focused degree to really understand. And the third part, we mentioned a few times today that one can bring in external experts. But does the legal professional actually have the background to assess what the expert says? So it's one thing to bring in a technical consultant and say, okay, I'm the lawyer, I'm the legal professional, here's my compliance consultant, my trading consultant, my technical consultant, and they will bring in their expertise. But can the lawyer actually assess what they're saying? Or can they assess if they go wrong? Can they assess and verify that what they say is factually correct, is concise, complete, and helpful? So those would be things I would be looking at. And if students can start think about that quite early on, that will certainly inform several career choices they can make.
Absolutely. And if I might add to that, in terms of the assessment process, I think academic institutions do not do enough of is teach students how to ask the right questions. That's important.
That's a lot to consider. In the time we've got left, is there anything else you'd like to say to our listeners? Any closing thoughts you'd like to leave the audience with?
I think Hong Kong is at a very interesting juncture, at a very interesting position. The whole of Asia is really. FinTech around the world is moving fast. One has to invest a lot of time just to keep up with different developments. Out here in Asia, it's certainly seen as a key industry for growth, and there are going to be tremendous opportunities. One wants to be prepared for that. One wants to do the research. One would like to network with professionals in the field to get more advice. And then you have to make a decision. That's what I'm going to focus on. That's where I'm going to be a real expert, and that's where I'm going to build my reputation, and I'll be the expert in that field and known for that. So I think that would be quite useful to be successful.
The most useful advice I ever got in terms of technology was during a job interview for General Motors. And the lady interviewing me said that you don't actually necessarily have to know the technology, because the technology comes at you fast and furious. But you have to know the terminology, you have to understand the underlying concepts, and you have to know whom to go to who will give you the right answers. Because as Don and you and I had been alluding to before, there are plenty of people who will give you answers. Most of them will not be anywhere close to correct. So that's something I think people should be aware of. And also, I think one thing about the class Don and I taught, a lot of our students found very radical, was the notion that sometimes the best expertise in an area is not found in the university, but found outside. So the ability to find the right expertise is also going to become critical in the future.
Gentlemen, thank you so much for coming back.
Thank you for inviting us.
Thank you, AJ, for having us.
There's no shortage of issues we can talk about, but we'll leave it there for now. And to our listeners, thank you again. And until next time.